Hello, friends. I welcome you all to this session of Indian Evidence Act, and this is the last section wise interpretation of the Act. And today we are going to see the last section of the Act, that is, Section 167. It is Chapter 11 which deals with it. This is the smallest chapter. Mind you, sometimes in prelims they may ask which is the smallest chapter in the Indian Evidence Act, then that is chapter 11, as it contains only one section, and that section is section 167. And what it deals with is that improper admission or rejection of evidence. So, what this section says is that suppose some evidence, these are evidences, this is also evidence. So, but some evidence has not been properly taken, and in spite of it, even if these evidences are not taken into account, which are improperly taken, there are some evidence which have been properly taken, and based on it, some decision has been given. But the decision is based on only those evidences which are admissible and relevant. Then in that case, only because some evidence have been improperly taken, there will be no new trial. So what this section says is that no new trial for improper admission or rejection of evidence. The improper admission or rejection of evidence shall not be a ground of itself for a new trial or reversal of any decision in any case. So, if there is improper rejection or evidence, then only on this ground, there will be no new trial. If it shall appear to the court before which such objection is raised that, independently of the evidence objected to and admitted, there was sufficient evidence to justify the decision, or that if the rejected evidence had been received, it ought not have varied the decision. So, just because some evidence have been improperly taken, but even or rejected, but in spite of it, had been the decision been the same, then that will this alone, that some evidence was improperly taken or rejected, will not be allowed to be a ground for a new trial. The object or the main reason behind this section is that technical objection will not be allowed to prevail where substantial justice has been done. So, if substantial justice has been done, then just because of some technical fault, the judgment need not be reviewed. Now, there are two cases. One case is that in case the evidence is admissible and relevant, and it is admitted by the court with the consent of parties. In this case, that is where evidence is admissible and relevant, then no objection will be taken at any stage of litigation on the ground of improper proof. So, in case evidence is admissible and relevant, then even in appellate court, it cannot be taken. Objection is cannot be taken that it was improperly taken, provided it was taken with the consent of parties. But if the evidence is inadmissible and irrelevant, then in that case, objection may be raised even in appeal for the first time. So, suppose evidence is inadmissible and irrelevant, then objection to it may be raised at any stage. So, in a case Padnappa versus Sivalingappa, it was said that the question of relevancy is a question of law, and it can be raised at any stage, whether it be in the trial court or whether it be in the appellate court. The question of relevancy can be raised at any stage. But question of mode of proof, That is a question of procedure, and that stands waived if it is not raised in the first opportunity. So, if the question is regarding mode of proof, or then in that case, if it is not taken at the trial stage, then it cannot be taken at the appellate stage also. So that's all, friends. So, what section 167 says is that there will be no new trial just because some evidence were improperly taken or rejected, provided that in spite of those evidences, the decision would have been the same. That's all. Thank you, friends.